Yeah, intellectual properties are like one of the less discussed topics.
It's very interesting career and also booming career.
Not be aware of like what is intellectual property.
The main challenge here in IP sector is people are not aware about IP. So unless going into a business, I talk about educating via IP these things.
So you believe that AI has changed the IP landscape? Hi Puneeth, good morning. Welcome to MultiDimensional Talks.
Hello.
Thank you.
Thank you so much for inviting me.
Thank you for accepting my invite. I'm so happy to have you here today.
Even for me also.
Thank you. Welcome to the show.
Thank you so much. Yeah.
Hi Puneeth.
Hi.
I'm so curious to know more about one of the interesting topics, intellectual properties.
Yes.
So
Yes.
I know you are the subject matter expert in this. So maybe let us start with the little background about you and your organization.
Yeah,
and
sure.
How you started and what motivated you to get into this field.
Yeah, sure. So as you said, myself Puneeth, I'm an advocate and also I'm a government authorized trademark agent.
Okay.
So while studying a law, so I had a subject called intellectual property rights. So but what happened before studying that subject? So I did an internship in IP sector, especially in a trademarks. So before studying a subject, so I got a practical experience while doing an internship. Then I understand the monetization things, how IP works. So what's a career about IP, especially the trademark. So I understand before studying a subject itself.
Okay.
Yeah, then I started studying. This is an optional subject I chose as a subject. Then I studied, so I understand properly, and I realized that this is a field I have to go. This has a lot of scope, and so I can express myself. Then I decided to start my career in IP only. So then I realized that so working under someone, so starting your own, so adds to you boost your career. So then I plan to clear a trademark agent exam. Even though that's not a mandatory for advocates, I need a certification in that and recognition from a government. So I decided to take that exam. So then I sat and studied for the exam, and I gained a knowledge, practical aspects, processing, everything by studying there. So then I took that exam and cleared it. So then I started working. One of the firm it's based out of Coimbatore. So I'm working as a partner to her. So then partner means I was working like independently only. So I'm looking out of Karnataka and Bangalore things, IP. So then under Nirmala Antony's guidance, I learned like monetization of things and how to get a clients, how to convince them. These all things I learned from her. So after that, I started my own. My firm name is STHAAPITH IP Solutions. So means here we do a trademark things, copyrights, and GI registration and GI things, and protection of your traditional knowledge under a Biodiversity Act and Plant Varieties Act. So and the consumer cases. So these are a main focus of our firm. So we are doing.
Good to know. So, and the name is like very unique.
Yeah, so there is a story behind it, Sthaapith. So I had one cousin. So she's little one, so 10 years old. So I always do a tickling, some torturing her. She's basically from Canada.
Okay.
So her accent is like a Canadian accent, English.
Okay.
So when I'll give a torture to her, she used to say, "Stop it." So that rhyming thing, I took from that. So then I found that stop it. Stop it is a negative word. So it tells that don't do that, don't do that.
Right.
That becomes a negative. So I don't want negative things to my firm name. So anyway, what do you mean by IP? IP tells two things. Number one, don't do that, like don't copy things. One is initiation things, like giving protection from a starting. So in Kannada, Sthapana means initiation. So I mix the two words, so it's become Sthapith. Sthapana plus stop it, it's become Sthapith. And so as a trademark for a brand name, you should give a coined word, like unique, not a generic.
Correct.
So these also become unique,
Unique.
not a generic.
Right, yeah.
So by that perspective, it suits good. Yeah. That's how.
Interesting. Nice, nice. Yeah, intellectual properties are like one of the less discussed topic, right? Many people are not aware they can make a career in it. So, could you please provide some like a suggestion, like how can someone make career in this one? So, is it like a difficult to make a career in this one? What step they have to take?
You said that intellectual properties are less discussed,
Yeah.
but it's nowadays it's one of the mandatory thing. Like just look around you, everything is like intellectual property rights. Regarding this podcast, in a podcast, so like your name of your channel can be protected as a trademark, and the process of a podcast protected as a copyright, and the mic system, chair, so everything so it's protected under intellectual property rights only. So then talking about the career, so I don't know why the people will think that it's a very confusing laws.
Yeah.
So because it gives a protection for granted protected rights, also non-registered rights. That's why it's very confusing. That's why people were not coming for a career or something. So but it's very interesting career and also booming career.
Right.
So nowadays, and look, so I'll give assurance you next 5 to 10 years it's a booming career, because
That's right.
two things like a creation and innovation never stops.
Correct.
Innovation never stops. Always we tell our children to do create, so do painting, do photography or something. So when it's come to the point of science, so engineers and scientists, so what they do, they innovate. So you have to protect it. When there is a lot of creation, lot of innovation comes, unknowingly or knowingly, they will pass off the product, copy their product unknowingly. So knowingly also. So when you build a brand or something over a period of time, there are certain people, so they will always try to copy you and they'll take a benefit from your brand. So these always increasing. That's why. So compared to other professions, there are less professions in IP. So when you choose this one, so you will become like a monopoly or something. So for example, best example is I frequently visit meetups. So usually a startup meetups. So nobody will come except me as a IP lawyer.
Correct.
So that's become monopoly for me. Like they have to come to me, not other people. So and career choices are for advocates, they can directly practice. The directly practice means when they got an enrollment, so they can get a attorney code from a trademark registry and they can practice. So for a non advocates, there are two exams to practice. One is trademark agent exam, another one is patent agent exam. Who clears a trademark agent exam, they can practice trademarks and geographical indication. Who clears a patent agent exam, they can practice with the patents and design acts. So and some other IPs like farmers' right, biodiversity. So for a biodiversity, the registration is not required. So it usually happens with court cases, if violation of traditional knowledge, those things. And plant varieties, it comes a part of the patents anybody can do. And trade copyrights. Copyrights is not means clearing exams is not required. Any person, any common person can go for a copyright website and they're registered. They should get a login ID and they can apply for a copyrights.
Gotcha.
So yeah. So if you want to, anybody can start with the trademark agent patent exams. They have to prepare for that. Exam is like the government, the trademark registry will conduct an exam once in a year. Usually that happens in the month of January. So there were two papers, paper 1 and paper 2. Paper 1 is MCQ, so 100 marks, and paper 2 is a subjective. You have to elaborate with, they will give us situations and you have to answer for those things. If you clear those two papers, like out of 100, mandatorily you should get a 50-50 in both of the papers. If you got 50-50, then you will qualify for a Viva. Viva is conducted in registry office only. If you selected means they will send a notice and you have to go for Viva and you have to clear a Viva. So in Viva means Viva is for 50 marks, 100, 150, total 250. Out of 250, you have to score 150 to clear that exam.
Got it.
So out of it will become like a 60%.
Okay.
So 50-50 means based upon how much you got in paper 1, paper 2. So you should get a marks in Viva. So if you got 150 out of 250, So you will clear that exam and you will certified with that. So like you will become a government authorized trademark agent or a patent agent exam. Then you can start with filing objections, oppositions, everything regarding IP.
Okay.
Yeah.
So do we need like a proper preparation for this exam? Is it
Yeah,
like
sure,
6 months or 1 year?
So that's not easy at all, especially the patent agent exam, even though trademark agent exam. So it will cover the all aspects of when we are writing a trademark agent exam, it will cover the all aspects of trademark and geographical indication. You should study the Trademark Act and Trademark Rules 2017 and also Madrid Protocol. Means there's a that is a international convention. So we file international convention through Madrid Protocol. So we are a member of Madrid Union.
Okay.
So you should read that international convention, the Madrid Protocol also. And along with that, from last year onwards, they included this geographical indication.
Okay.
So you have to study a Geographical Indication Act and Geographical Indication Rules. So you should be thorough. So then only you can clear that one. So for patents, Patent Act and Patent Rules.
Okay.
So and the International Convention about Patents, along with the Design Act 2000. So that's a new act. It came on 2000. It talks about outer structure of a design.
Okay.
So that is included with a patent. So there should be a proper preparation. So bare knowledge you cannot go and write. So if you prepare well, then only you can write.
Okay.
Yeah.
Approximately some 6 months or something?
Yeah. It will take. So and also they'll ask a question, tricky questions, and so especially with the paper 2, how it means they will give a situations for you, means
More of a case study.
yeah. Like they'll ask directly. I think I got a question like they will give a situation and what you will do from that situation. Like if you got a how you will file opposition, what is the procedure of oppositions, like objection, why objection. So these things means you should use your application of mind to answer those things.
Gotcha.
So and study from Bare Act, but they will not ask exact questions to Bare Act. You should use your application of mind to answer.
Gotcha.
Yeah, that's it.
Yeah. So as you have mentioned, right? So this is one of the demanding role, but like unless until somebody is into like a business or something, so they might not be aware of like what is intellectual property. So they might not know. Okay, so we are getting infringed, right? So maybe you can touch upon the little background about like what is IP and what type of the IPs we have.
Okay.
How it is different from each other.
Sure. So its IP full form is intellectual property rights. So the name only suggests that intellectual property. So the properties arises from your intellect. So to produce those things, you will use your skills. So and creativity, like knowledge, money, advertising for a brand. So those are properties, usually assets, which comes from your intellect. You create that one.
Correct. Yeah.
So especially what you will do after buying a property. You will go for a registration office, you will draft a things like a sale deed or something, you will register. While you register, you want that property should be in your name. So if somebody comes and occupy that property, you can show that it's mine, so by showing a proof. Similar way, these are also our properties, our assets, which arises from us. So we should have a right on that. So not only a right, we can monetize it. What are the profit or a revenue earned from that property. So you are a owner and you should claim that one. So and if you created properties like intellectual properties and did not protect, did not worried about those properties, means somebody comes and they copies or something, that may happen, especially with the patents. So what happened, I know that many, so I usually frequently visit the startup meetups. They have an idea, they will come and pitch to investors and all the audience without any protection.
Okay.
What if one of the person copied, that means?
Correct.
Yeah, so that's why before pitching, before announcing, so it's better to have intellectual property rights. And the intellectual property, in intellectual property there are different types. So number one, I'll talk about trademarks. So what are trademarks? Trademarks means a mark, logo, name, slogan, tagline, sometimes sound mark. Sound mark means any jingle which is used for advertising. Like you heard about Nokia, some jingle.
Okay.
Yeah, so that is called a sound mark. Shape, trade shape. You saw the 7 Up and Mirinda bottles.
Right.
So even though without label, without the 7 Up or Mirinda, you can identify that this bottle belongs to Mirinda or 7 Up. How? Or a Coca-Cola bottle,
Okay.
based on a shape.
Okay.
So that shape can be trademark.
Okay.
Like these all comes under trademark, which is used for advertising or labeling in a market. So that's a trademark. Next come copyrights. Copyright is a creation. So like artistic work, music, sound recording, cinematographic films, and video, painting, and software coding. So these all comes under copyrights. So
Software coding comes under copyright.
yes, copyrights. So if you wrote your code, you want protection, means you have to file under copyright. So yeah, but so what we have to understand means when we come up with any type of intellectual properties, first we have to understand what type of intellectual property, whether it's a trademark, whether it's a copyright or a patent. So then we have to apply according to that. So means any book we cannot protect under a trademark. So any book we cannot protect under patents. We have to protect under copyrights. That's the difference.
Okay.
And coming to the point of patents, science innovations, science discoveries comes under patent.
Okay.
So that should be patented. So that's give a full right to monitorize it. And for a patents, if you are filing for a patent, there are 3 rules. One is that should be a novel. Novel means new. And next one is non-obvious, means that should not be generic or something. It should be a new to the market, nobody knows. And another is industrial applicable. It should be applicable for industry to use. So like you created something and I'll keep it for myself, means no, that's not patentable. It should useful. So like any science innovations, like they prepared a vehicle. So in earlier times, so I prepared a vehicle I use for myself, means no. So you have to monitorize it. So that should be useful for public. That's a concept. Next is geographical indication. Geographical indication is similar to trademark, but there is a difference. So the name of a places you cannot be trademark, means you cannot claim that is mine. For example, there are many geographical indication in the name of Karnataka's things like Mysore Pak, Mysore silk, Dharwad peda, Ilkal sire. So the products which contain with the name. So Champagne is a place in France. So but it is there is it's a different procedure than a trademark.
Okay.
So the different is, so who can use a geographical or a name of a place. So for example, we'll take an example of Mysore sarees or a Mysore pak. The name from Mysore, those region, the people who belongs to those region, they have to make an association.
Okay.
Then they have to go for GI office, like we have to register for a GI. So they will get a GI tag. So that means the manufacturer belong to those places can use means for that also they will become a registered user. Then becoming a registered user, they can do business to that name. That is geographical indication. So next comes Designs Act. Design is quite different from copyrights and patents. See, it's similar like outer line of design, like a car design. Have you saw any car with the same design? No, right?
No.
So there is a different designs. What they do, the outer line of design, there is nothing to do with the machinery, programming, something, only design. They will protect under Design Act. And so if they got registration for design, means they only have authority to use that design. Especially this happen with a car and some machinery things, outer designs, and some of the bottles, what I said, that also comes under, if they are doing a trade, means trade shape that will come. So if you, especially the fashion, I forgot to mention, fashion industry. So like any new dress or like big companies, they have prepared, means they will go with the Design Act with the fashion.
Okay.
So and next one is Plant Varieties Act.
Okay.
Plant Varieties and Farmers Act. So this is looks like patents, but it's not a patent, because so the breeded plant, they will find out a new it's like discovery of a new plants. So modify that one. So the giving a registration for this. And for usually farmers will do, and also pharma companies, so like agri companies will do. So they will go for a farmers right, like a breeding or something. Next comes last one is the Biodiversity Act, which is I like this a lot, but the thing is it's less monetization. That's why people won't aware or practice these things. Like it's basically protection of traditional knowledge. For a best example is you go for a forest something, they you will find a forest people, they have some knowledge which is transferred from their ancestral, so only they knew, and that knowledge is useful for everybody, like people who live in a city also. So what they'll do, some of the businessmen or entrepreneurs if they find that knowledge, they will convert into a company or a product, they will sell in a market. So and credits and a profit that will go for a businessman who did it.
Right.
So what Biodiversity Act says, you should pay royalty amount to them, some amount. So and it will not restrain you to do these things. You can do, but because of you only, like a businessman only, that come into our world. So that's why you can do, but you have to give something to them. So without giving anything, so you can claim on that. So nowadays, the sad reality is these things happening, but the amount of royalty or money, it's is not giving, also giving like small the thing is, I heard I don't know the product, but they give a badminton rackets. What they do with the badminton rackets, and also misuse of those things from the community member also happening. So it's basically work with the traditional knowledge, protection of traditional knowledge, biodiversity. These are all a type of IPs which is currently there.
Each category is governed under the different act in
Yeah,
India.
different act and different offices also. Like for a patents we have a patent office, for a copyrights we have copyright office, and trademark also we have a trademark office.
Okay.
So and also it has a validities. For example, trademark, if you got a registration means it's a 10-year. After 10 year you have to renewal. It will be your name, but you have to renewal. If you're not renewed means it will expire. But copyrights, it's a
Is there
lifelong.
any like a buffer timing after 10 years?
6 months.
Okay.
Yeah, they will update you from 6 months itself, and after 6 months also you can renew it, but you have to pay more fee.
Got you.
So rather than how much is there, no, like fine. So you have to pay a fine, and you have to renew it. So and for copyrights, it's lifelong plus 60 years. So that's long you have a protection. For a patents, it's a 20 years. For a designs, 10 years protection. After you can renewal it, like that.
Yeah. If somebody is not renewing within that time frame, right? So can that be allocated to the other person? If
Yes.
they
If
are
anybody, other person can use. And also in a trademark, there is a thing called a non-use of the mark. If a person bought a trademark or a registered trademark and he's not using for 5 years,
Okay.
and it mark will be removed.
Okay.
So under a provision of non-use the mark.
Okay.
Yeah.
So then that can be allocated to the different people
Yeah,
if they are applying.
yeah, they have to apply.
Okay.
They have to apply. For non-use also, somebody files a rectification. If someone files a rectification, so then only it will be removed. So other than like if a trademark registry found that they are not using, so nowadays the trademark registry has a lot of work. So why lot of work means in India we have only 5 trademark registry offices.
Okay.
And there is a lot of filings happening, and they have to examine everything. That's why it's the trademark process is becoming a delay.
Okay.
So in meanwhile, how can they check every mark they are using or not?
Correct.
So that's why they have anybody like I have a mark and I'm not using, but you need that mark. So you can apply rectification.
Okay.
So then under the provision of non-use, it will be removed. And then you can get then you apply for that one, you will get.
Yeah. So normally how long it takes for the registration process?
So the process, I'll explain the process first. So before going for application, first thing is you have to research on your mark, because every mark cannot be registrable. There is a rules and regulation, especially I tell the class also. Class 9 and class 11 governs of a trademark act governs with the registration. So 9 tells that absolute grounds of refusal, means it absolutely tells the mark is not registrable. And another one is section 11, which tells that it will compare the mark, whether somebody is using a similar, identical or a same mark. So if they are using, you are not allowed to apply for that mark. Means you can apply, but it will reject it. So once you find out those things, and you have to identify the classes in a trademark. Like for example, there are 45 classes. That is called as NICE classification. That's the international classification. India also follows that one. So there are 45 classes in that, include goods and services both. So before 2000, before new act, only goods were protected. So after new act, like a trademark act 1999, services also added. So we have 45 classes, which is divided into different types of business. For example, class number 41 talks about entertainment and education. 42 talks about software as a services, and 5 pharmaceutical things, and 43 about hospitality industries. That's how 35 businesses. That there are 45 classes. You have to identify your business is which classes. Sometimes what happened, the business comes under 2 or 3 classes. For example, downloadable apps comes under 9. And software comes under 42. And they were a platform of e-commerce, that also comes under 35. If a mark is doing a business out of these 3, so you have to go with those 3 classes only. So you have to identify classes. My business belongs to which classes. After identifying these things, you have to go for application. So after application, so you will get application number. From that time onwards, you can use a mark called TM. So that shows that temporary mark, and from that time itself, that belongs to you. That's it. So then the process will start, application. So there is a person called examiner. So he will examine our mark. He will find out that whether it's you have any defect about a mark, or mark is absolutely fine. He will identify that. If you have any defects, mark is not good, he will object us. He will object and tells the ground why I'm objecting. So we have to respond for that. We have a 1 month of time to respond that one. So if you are not responded in that 1 month, means the mark will be abandoned. So application process will end in that stage only. So what we have to respond for that mark by convincing why I have to give a mark. If he satisfies, good. Otherwise, he will call for hearing. That is called a show cause hearing. So we have to appear for a hearing and convince him. So if well and good with the objection stage, it will go for mandatory stage called as advertising stage. So advertising stage is for a 3 + 1 months, total 4 months. So 4 months.
That's for trademark.
Yeah, I'm talking about trademark. So 4 months, that will be in a advertising stage. Why this stage means, this is a window for someone else, like someone else in India or international, using the same mark. They can file opposition by telling, so don't give a registration because we already got a registration, or we already using this mark. So that's opposition. That's why that should mandatory go for 4 months advertising period. If nobody filed for opposition, or if they filed and they won in opposition, means they will get a registration. Usually, so nowadays, to be practically, it will take more than a year. More than a year. If you got opposition or objections in the middle, means it may reach 2 years also. But no need to worry. But it will start with, say, IP. How work means first come first services, or people like society believes that you are earlier to this, means you have a protection. So it starts with the day of application itself. So day of application gives a proof that you are already using. You are also using a TM. So don't worry about the period of a time like 1 year or something. The process is there, but why you are applying. So you are claiming rights for that, right? So that determines the first day itself. And also you can apply claim the date of your using. For example, I'm using a mark from last 10 years, but I am not aware about trademarks, but I'm applying now. So but in that you can claim that date only. But for that you should have some evidences. Along with the application, you have to file that affidavit, something that I am claiming that. So in your certification, you get that you are using the mark from that date only, from 10 years. Yeah.
And you have also mentioned about the monetization, right? So if somebody register, so they can get it monetized. So how exactly it works, right? So and what is the benefit of like a
registering? Yeah. So number one is legal, right? You will get a legal, right? So like need not to prove that you are a owner or something. You will get a ownership. So monetization advantage is it becomes one of your company's asset. Company's asset. So at the time of like you are selling your company, so you can also sell your mark for some amount of money. So like you have one logo or something in a starting days, it's just a logo and a name. So but couple of years, like you will put advertising or something, it will become a brand.
Correct.
Brand, and so people will buy your product by looking that one.
Yeah.
So for example, Domino's is a company from America. So but who handling in India? Jubilant Foodwork, right? They bought it. So they bought, and they are not selling through Jubilant pizzas.
Right.
They are selling pizzas to Domino's only. Why? It already got a reputation. So they bought it. So it means after based upon the value company mark value or company value, you can sell it. So number one advantage, you can means you are not a registered trademark, means there is no ownership of right, means it's difficult to do that, and yeah, it's almost difficult. So second things, you can give a license to use that mark and franchise it. So those advantages are there, and mainly protection
You can make
from
it as a revenue
license.
line.
Yeah, license. Give a license to somebody to use that mark. So because you are reputed, you are put your hard and effort, money, everything to advertise it. It's a reputation. That's why giving a license. So see, you start with the same product or business having my logo or something. So by seeing a logo, or the people will think that you are only doing that business, and the people will come. That's licensing and franchising. Franchising have to make. And one more thing nowadays, why I have to make, so nowadays most of the product is selling in e-commerce. E-commerce, Amazon, Flipkart. So earlier it was fine. What happened? So the counterfeiting products or fake products started selling in e-commerce. So and what happened? Like a owner started filing a case against Amazon or Flipkart. So that's why this e-commerce platform what made. So you should have a trademark registration before selling in e-commerce. That made it mandatory. But if you file an application and you got a TM thing, you can sell it. So, but you don't have a trademark registration, means they will not allow. The rule is not there, but they will not allow because of these legal issues what they faced.
Right.
And main reason is protect from copycats. So you are growing means there are many people, the enemies
Who will copy.
Yeah, their copy. See, they will not worry about, they will copy for short term. So they will make a product and sell in a railway station or something for a short term. They will make a profit of in the 1 year or 2 year. They will stop using that mark. They will start another logo to copy. So there's lots of happening like this. People should aware. Yeah, these are the monetization things about trademark. Coming to the point of copyrights, copyright, as I said, it's once you create it, it's already your mark. So to prove ownership, to have clear evidence, you have to get a copyright registration. And also, it's get a lot of confusion about copyright. So how means, for example, sometimes copyright work may be a shared ownership. So in a copyright, main thing is author is the same. Owners may different after passing it to something. So once who created a work or something, he will become an author and also automatic owner. So what happens in some of the cases, the thing is created by multiple people. For example, you take a video, so the thought of video and money spent like a studios or something is a one person. He is also owner, he is also author. Then a videographer, so he used his skills to make a video. He's also become a owner. Editor, he's also become a owner. This is called as shared content, shared ownership. So all these people have a rights over this. So when if you don't have any contract with the people like videographer, artist or something, so they all are shared. So that's why you should have a contract in these things. And the next is, so if you file for a copyrights, so there is the process of copyright is when you file for a copyright, there is a 1 month of mandatory period for observing. So in that time, so anybody he is a co-owner of that product, or so anybody is having similar thing, they can object it, and the same process what I said for trademark, that will happen before a copyright registry. So if nobody filed, like a co-owners or something, they were not aware first of all. So they in month they will not file or something, he will become a full owner. That's also one of the advantage. Means unknown advantage.
Got it.
So if you're not did a copyright registration for those things, means they also have share. When you're going to sell or monetize it, they'll also come. They can also file a case on you. So it's also my work. So that's a hidden thing in a copyrights. You should know about this.
Okay, got it.
Yeah.
Got it. If somebody wants to get into the IP field, right? So is law degree mandatory for them, or non-law graduates also can get into this field? If yes, like how they can get into this one?
We'll take two things. One for a law degree people, one is for a non-law degree
Okay.
people. Law degree people have directly can practice. It's one of the law. So when the case comes into a court for an infringement and passing off, they can handle in a court. So every type of IPs. And so to this process and all these proceedings to practice, they have to get a attorney code. So attorney code, it's a simple, go for a which one you want, like a trademark attorney code means go for a trademark registry website and give the what are the details they want, and they will issue a attorney code. So after getting attorney code, you can apply all the applications, opposition, everything by being a advocate. So that's the easy thing. So for non-advocates, and also CS, company secretaries, they are also without passing an exam, by giving their details to the trademark registry, they can become a trademark attorneys. So for other people like normal degrees having people, they should mandatorily to take an exam called trademark agent or a patent agent exam, and they have to clear it. Then they have to practice in IP. Like what IP that matters? Like if they have cleared a trademark agent, they have to practice in a trademark GI and some others. And if they cleared a patent agent exam, they should practice patent and design those things. But they have a limitations. They can't fight a case in a court.
Okay.
So because they are not advocates. So the who are advocates, they only can go for a court.
Okay.
So behalf of clients or something. So the limitation is they can file. They can appear for a show cause hearing, they can respond for objections, and they can file objections, oppositions, and counter statement, they can file a counter statement, and appearing for a hearing for opposition and counter statement. So those all things, the people who are like agents, trademark agents or a patent agents, they can do, except appearing in court.
Okay.
Yeah. So they can hire advocates for appearing in court for their cases.
Okay.
So advantage is for advocates only. So they can do a both.
So as they cannot appear in front of the court, right? So what procedure they can cover, like what exactly their role?
So you're asking about non-advocates.
Right.
So application process, and if they find any objections, means responding for objections, and like if a examiner is not satisfied with your response, they can call for a show cause hearing.
Okay.
You can appear for that show cause hearing and convince a registry. And next stage is in advertising stages, if somebody file opposition, and you can also file opposition, being a agent you can also file opposition.
Okay.
And responding for opposition, so and appearing hearing for opposition. So and any issues with the registration process from the point 1 to point until, so the process, full process, if you find any things with a registry, you are only able to communicate with a registrar.
Okay.
And government officers. So when it comes to the point of passing of cases and infringement, which is exactly like copying, and if you claiming the damages or a profit, so apart from a registry, so you cannot claim those things before registry. You only deal with whether that is registrable or not. That's it. So when from the copycats or something, if you went for a court, means you are not allowed. So the the court says that only law practitioners should come to the court rather than these things. So also they don't have a bar membership or those things. That's why only advocates can appear before the court. So for cases, infringement and passing of cases.
Okay.
Yeah.
What is the pre-qualification required to appear for this exam, IP exam?
Just you should have a degree. That's it.
Okay,
Normal degree. So then you can apply. But for a patent agent exam, if you want to become a patent agent, then mandatorily you should have a science degree, like in engineering, MSc, BSc degree. Not a diploma courses will not consider as a degree.
Okay.
And science degree. So if you don't have a science degree, means you cannot appear for a patent agent exam. But for a trademark, any degree is okay. Yeah.
Okay.
That's a pre-qualification. That's it. And you should have a knowledge about patents or a trademark, obviously, to clear that exam. Yeah.
Okay. After the clearing this exam, so is it mandatory to practice under someone, or they can start by their own?
They can start by their own. They will get a license to practice.
Okay.
Like how chartered accountant clearing the exam, they will practice by their own. No? So similar to this trademark, the people who clear a trademark agent, they can practice by their own. So that's why they give the exams. Like you'll get a license to apply trademark applications. To handle these things, you can apply. So to work under someone, you don't need any what the trademark agent or something. You should have a knowledge or something. That's fine for work under someone. So this will help you to practice by your own.
So it's not mandatory to practice under someone. So there is no mandatory internship or something, right?
No, nothing. So just give an exam, clear it, and you practice by your own. So that's it. Yeah, you have to create that code. It means they will give you after clearing that exam. So by taking that code, you can have access to websites like filing websites or some. The government website are there. So you'll get access. By getting that access, you can file or do anything. Yeah.
And for law graduates, so does it add any value if they appear for this exam? So does it differentiate them from the others?
Sure, because that's how I did. So I'm a law graduate also, and also I gave a trademark agent exam. So why I gave? So that tells advantages. So one is so you will thoroughly know the concept of a trademark. So because if you don't know thoroughly means you cannot able to answer your clients.
Correct.
Or something. That's why that's give a qualified tag. So when you go for your client or something, that will give a qualified tag. Just getting a trademark attorney after a law graduate, so they will not issue you a certificate. So for a trademark agent, the government will give you a certificate. So you can show to their clients that I have this one. So that the clients will believe you. You know the knowledge. So because they knew it, so you gone process of some examination. So that is also not easy exam. So they knew that he knows some of the knowledge about IP. So that's why he cleared exam. So that's a added advantage. That's helping me a lot. So because I works pan India, like IP works virtually. The filing, except court hearings, the filing objections, appearing for hearing, so works virtually, and it works jurisdiction basis.
Okay.
So for example, Chennai Trademark Office handles Andhra, Telangana, Karnataka, Kerala, and Tamil Nadu.
Okay.
So any application from these regions should mandatory go for Chennai only.
Okay.
So likewise, so Delhi region have go for Delhi or something. So sometimes I get cases from Delhi, Mumbai. So recently I did one case Mumbai based.
Okay.
So for that we have to approach Mumbai office. So we cannot go directly for one of the cases something. That's why it works virtually, opposition, hearing or something. So that's why we connect with the clients based upon Mumbai, Delhi, everywhere. So without meeting directly, just a virtual meet, they should believe you, right? So I just advocate, I know about law, means it's difficult to believe them. So they will ask for your company details, the firm details or your details, qualification and all. So when you show your certificate of a trademark agent, they believe that. So you are, practicing trademark and you have a knowledge like that. And also that helped me a lot. Many people said why you are giving an exam, even the advocate or something. But I knew that I'm practicing, so I want to practice independently. So, and I may require these things. And it helped me a lot.
Got it.
Yeah.
Got it. So after clearing the exam, if somebody wants to start by their own, so do you have any suggestions for them, like how to set up their own organization or how to get the client or how to reach out to the client? Because initial stage might be like very difficult, right?
Yeah, even I face that.
Yeah.
Even I face that. See, first of all, the main challenge here in IP sector is people are not aware about IP.
Correct. Yeah.
If they're aware about IP, especially with the industry, startup or creators, they knew about IP means first they go for a registration or something.
Right.
That will make our work easy. the awareness. So that's why even I'm working on educating people. So first, unless going into a business, I'll talk about educating why IP, these things.
Correct.
Then they will realize, oh, I need IP or something. So that's a real challenge for a practitioner who's starting early. So next is networking. You have to do a lot of networking, meet up people. So how all the ways you can connect with the people, do those things. And research works for a non-application. So application is main thing. And also some oppositions. You have to do a research, and you have to find a similar marks whether you're using. And first thing, you should be capable to answer all questions what they asked.
Okay.
Yeah. So if you are buffering, not able to answer or something, means they will drop out, because it's a reputation of their company.
Correct.
Yeah, it's a brand value or something. That's why you should be knowledgeable about IP. So yeah, what I suggest means, yeah, it might be difficult, but when you see in a future, work for a 1 or 2 years consistently networking, consistently reach out people, consistently educate them. So and slowly that news spreads, and I am sure about this. So next coming years, the people will get a knowledge about IP. So and value of IP. Now only the most of
Right.
the people are got a
Right.
knowledge. So you will, by seeing the numbers, will become insane. Because every week I used to go through the trademark journals. It will publish on every weeks.
Okay.
Minimum 2,000 marks were published for a week.
Oh.
Minimum 2,000. 1 week I got for 4,000.
Oh.
So this is for advertising stage. So when they publish in a trademark journal, means
Right.
it will be in a advertising stage. So just imagine how many applications were rejected in this stage, objection stage.
Correct.
So imagine how many applications are filing, and it increasing only.
Okay.
So when the increasing, so the conflict is also increasing, right?
Correct.
So that's my advantage. That's why I'm telling people are becoming aware of this IP. So as of now, what I feel means, by attending these meetups and networking with people. So out of founders, I'm talking about founders. So 80% of the founders is not aware of this IP.
Okay.
So within that 20% only, these much of applications are coming.
Okay.
So think about 50 or 60% of the founders knew about IP, and they're executing IP rights, and they're fighting for IP rights. Means it has a huge profession. That's how I thought, and I came here. So that's I suggest for new people. Yeah. And one more thing. So working under someone. So nowadays there are tools for applications or a research drafting. So most of the things, even I use AI things. And earlier days they will hire a junior people for do those things. So applications. And earlier it was a physical applications. Nowadays it's become a online applications. So means you are well educated, knowledge. Have a skills about IP, then only you can survive. Just small things like writing applications, filing, drafting mails. So if you are looking for those kind of things, means it's difficult to survive. Yeah.
Good, yeah. So you believe that AI has changed the IP landscape?
See, actually they can't replace with IP.
Okay.
So because I did this one, because I tried this one. So I said about trademark journal. So I go through trademark journal. I'll every week I'll find for similar marks whether there or not. I use the AI and the ultimate most AI things for these things, but they cannot do my work. Finding a similar mark. So what I do, I'll take a mark and I'll search for a similar through website. So but this government website has a CAPTCHA thing. CAPTCHA AI cannot crack that one.
Okay.
So that's AI can facing now, but if it's but this is not possible because the government things are about contained in a website or government information. No, that's why AI alone can not do. And
But
for
we
application,
can make use of AI.
yeah, for small thing like finding a classes,
Okay.
filing an email draft. So these things we can use, but it cannot replace. And also it can give a information AI do like this. The section 107 tells you these things. But being an advocate or being a professionals, we have to use our mind. So that being an advocate, you should use your jugaad mindset. So and do jugaad things to work on your own way. So AI cannot do those things.
Right.
So that's why, yeah, it can help AI. But what I said means don't try for those small jobs like applications. So those things. But use your brain,
Right.
application of mind, skills. Then you have chances in IP. Yeah.
And do you also see any changes in IP laws because of the technological changes or technological enhancement? So especially like in India.
Actually, it's frequently changing because IP laws are new laws. Means it was there, like a trademark act. Trademark act is 1999 and established in 2000. Enforcement in 2004 or 3 maybe. So it's been recently compared to other laws. Like we have a laws from 1907, 1880s Contract Act or something. So but and Design Act 2000. Copyright Act is 1957. But yeah, based upon a technology, so it's keep on changing. Like in 1957, there is no software things.
Correct.
So there's not a resistance, but now it added. So based upon a situation, it's changing. That's why we should always, being a professional, we should always keep eye on what's happening in a market or something. Yeah, it's changing.
Do you see any difference between the international law, like IP law, and like what we have here in India? So Indian IP law. So is there any procedural difference or any difference in the content?
There is no much difference. Almost similar, slight changes, slight. That's it. So changes with pricing money like the government fee and the government fee in other countries. So that's maybe difference. And also we have an international convention for every IP thing.
Okay.
So the country which is bound to those conventions should follow the similar things. So that's why we also practice international laws. When you go through the international act, it's almost similar except the like sections, allotment of a section. So I don't see much difference in other countries IP laws to our country IP laws. Yeah, so for applications there are conventions. Through that convention we can apply. Yeah, most of the countries, like except some of the countries, they are conventional countries. They are bound to, they sign for conventions, so they follow the same. Yeah, based upon that conventions, they were created laws here. So that's why I don't find any much differences, except the fees, some of the slight change in the procedure. Yeah.
Do you also deal with the international crime?
Yes. So I won't file directly before other countries because other country laws not allow. Like for example, UAE. So UAE or US or something, they need filing their country. They need their advocates or their agents. But there is a thing called Madrid Protocol. That's an international convention.
Okay.
Like through that convention, so I can file anything with a like the member countries.
Okay.
Most of the countries are members. So for US, I can file directly with the Madrid Protocol. That is called international registration.
Okay.
So, but for that international, you should have a Indian registration first.
Okay.
Then you have to go with the international through Madrid Protocol. First, in that application, we have to mention which all countries we need protection. So what all the countries we mention, they will send our application to those all countries, only those all countries. Like I want, so Europe become a European Union, so any country you can, but in African countries or some other countries, you should mention. If Europe means you just mention European Union or US, they will send our application to their country.
Okay.
And they will check whether somebody is already have their own marker check. Based on that, they will grant you an application. And also, what I said, I cannot directly apply to some other countries. Likewise, some other country people cannot directly, some other countries agents cannot directly apply through Indian IPs. So for them also, I am helping. Like for a UAE people, so don't want come through a Madrid Protocol. They want directly Indian registration means we can do that also. For those things, they need Indian advocates only, or Indian professionals of IP professionals only. Okay. For international clients, like that I handle. So I also handled opposition of other countries.
Okay.
Yeah, that's how process is happening in about international. Yeah.
How usually client will reach out to you? So what is the like a mode of the communication for you, or Do you have any like a website or something?
Yeah, I have my website, my own website. It's a sthaapithtm.
Mm-hmm.
So one is website, and first thing as I said, I love networking people.
Mm-hmm.
I do a lot of networking, and I'll promote my firm there. So and that's how I connect with the people. And another thing is I'll research on in IP thing. Like I'll search and find out similar marks are there who are violating. So I have an intent to do that work only.
Mm-hmm.
So even though I'll work a lot on this, so and I'll educate them. Like if somebody is violates or somebody third party is using the mark means I'll tell them, see, like third party is using a mark, this is the action you have to take. So I'll approach them only. So
You will
that's how,
intimate them.
yeah,
So okay,
intimate
this is
them.
what is happening.
Yeah, so that's how they become. They will first check, they will aware about the issue, and they will come to me. So that's how it's happening for me.
Okay. And you have also mentioned, so when you meet the people, so you are surprised to see they are not aware of the like IP, even though if they are like a founders or the business owners, right? So do you have any like a piece of suggestion for every business owner or the founder, or like for the startups? So what exactly they need to follow, or what strategy they have to follow in terms of IP during their like initial stage or early stage of their business?
Yeah, sure. I'll tell. So first thing is founders will always think about growth of their startup, investment, and advertising things. So okay, they will never think about IP in an initial stage. But first thing they have to think about IP in several ways. So what they do after they have an idea. So they were in an idea, they were ideal in an ideal stage or something. They will make into a product.
Correct.
So for getting an investment, what they'll do, they will go for investors or events or meetup events to get a co-founder or something. Many reasons they will go. What they do, they will do, and they will tell about their idea, what they do, without any IP. So without any patent registration or a software code registration,
Right. Yeah.
they will tell. So what the people like, it's happened with me only. So I had a conversation with one of my friend.
Okay.
So he's my PU friend. We have met a lot for last 5 years. So we had a plan to meet. So on a weekends, I said no, I'm busy on a weekends. I used to go for meetups. You can come to that events. We can meet there.
Okay.
So he said, what I'll get. So I said, networking people added advantages. Many people will come and pitch their ideas. You can steal their idea.
Okay.
I said, so that's what happened. It's making funny, but so when you go, that's what I'm trying to
That's
tell
true.
is, yeah. So when you pitch your ideas, so the one of from the crowd may copy that idea and make a
They can
patent,
implement.
yeah, patent, take a rights, and that will become to his the who applied. So after that, he can sue him.
Correct.
So that's why you should protect. And coming to the point of brand building, what they think, like they will create so like a logo and start, they start using it, marketing or something. So one thing, they didn't do a research on a mark. They might somebody from whole India, like if they are doing a business in Bangalore, they might have somebody have a same logo or mark in Mumbai, Delhi or something. So they will aware after your business get establishment for a 1 year or 2 year, it will reach out to clients all over India. So they knew, they get to know about your mark, so they can see you. So after that, what you have to do, you have to rebrand your product. That's it. So that's why in early stage only, when you create your product, first do a research whether it's somebody is using or not, whether it's a trademark registrable or not. If not, there is a time to change that mark, right? So rather than in a developed stage, one thing you have to rebrand, otherwise you have to spend a lot of money for legal things. That's what. So and you need not to worry that there is a two types of application. One is prior user, proposed user. Proposed user means you just have a mark. You not have started a business. You can apply it under a proposed user.
Okay.
So the day onwards you will get a rights. So that's a thing. That some people will make a mistakes about a brand. So yeah.
So we also see increasing trend of social media, right? So and you have also mentioned that so they can also get registered their channel or their content. So that is governed under which section of the IP?
Two types. One is for comes under trademark and a copyright. Main thing is a copyright. For logos or the name of a channels comes under trademark registration, and also the intro line. What you said, no, like any music of the intro music or a intro line that can be registered under a trademark. And any jingle you used for an intro line only, not a music, just a jingle used for intro line, that can be registered under trademarks. Other than the script and music, if you created by your own, and visuals, that's all comes under a copyright. So, and the important thing is where you are uploading. So if you are uploading for a YouTube, Instagram, so as I said, copyright is once you created, it's already always become your right. So as a copyright, no need to register it. But the thing is, when you give upload in a YouTube or Instagram, so uploading itself giving a license to them to, like use it for a commercial purpose. Means commercial purpose means they can have a ad revenue out of them, and they have a right to share. Means those kind of a license you automatically give. So for a YouTube or a Instagram, like any platforms. Other than this, you can claim on a rights of somebody uses the same name of your logo, or a YouTube name, so or a jingle or a same script, you can claim out of this. So also you can give a license out of so license to make revenue out of these things, the one commercialization you do. And also you should mandatorily aware that the music or a visuals or a script you are unknowingly or knowingly using from others, so which they are created from others. So unless you have a license or a contract to use those things, so that should be, you should check first before using. Like what happened for making a reels, so they will use a music of others. So you are making out of like a simple reels, they will not object you, but you are reel making money out of that things for ad those things.
Okay.
If they are using, means they will they can sue you. So these things happening a lot of things in nowadays. So there is a lot of cases are arising, especially from the YouTube only.
Okay.
So because that thing. And content creator, if they want to protect those things, means as I said about content, ownership sharing. So should aware about ownership sharing if you are claimed to be a sole owner.
Okay.
So that's thing. Also you can, by copywriting it, you can monetize, sell it, license it. So main thing for earning a revenue. So but as I said, for copyrights, registration is not mandatory. But if you want a legal protection, you should go for a copyright registration. And copyright registration is a very, like compared to other IPs, it's very smooth registration. You need not to go for attorneys. You can create, file your own if you have a bare knowledge.
Okay. Yeah. So they can directly reach out to the practitioner and
Yeah,
they can get
yeah.
it done.
Yeah. So, but I suggest is like if you are copying someone's, get a license.
Okay.
And for a main movies or a short films, so which you are earning a revenue from that product. So get a NDA contract from a co-host or a editor or something. Just simple contract, make it so that they cannot claim their ownership. So before doing that only, so what happens, they were not aware. But what if they met a people like us, they are a friend of mine who have a knowledge of IP. So if I tell them you are a co-owner, you can also have a claim.
Okay.
If they meet a people, they'll get educated and they can claim you.
Okay.
So that's why these things should be keep in mind.
Okay. And many people might not aware that their content or their channel name is getting infringed, right? So in case if they find out, or if they want to find out, like what is the procedure, and once they find out, what is the procedure to claim for the infringement?
See, first thing is there is US copyright, there is an act. Okay. So that is followed by most of the platforms, like
Okay.
international platforms, Instagrams, YouTube, those things. So there is one clause tell that give a notice, like what that notice comes under that act. So first thing what I have to do, if you find means send a notice to the YouTube.
Okay.
Like what they do, suddenly they will delete that video from posting, they will delete. After then, through Indian law, So like assessing what are the losses you got, what are the damage
Okay.
you got, go for infringement, copyright infringement to the district court. So then based upon so then assessment will start, what type of damage, how much compensation you should get. So after, if they lose if we lose a case, means the people who filed, so again they can make appearance in a YouTube. So first thing is means give a notice to the platform. So that's how you have to do. Yeah.
Okay.
This is for non-registration users also.
Okay.
Yeah.
So how it is benefited if it is a registered users, right? So,
Copyright.
Um,
In a
yeah,
copy.
any IP. So if they get it registered and if they don't get it registered, so like how they will get it benefited if they get registered?
First thing is proving a ownership is very difficult. Very difficult. How the people will know that you are a owner of this, or a owner of a product or a brand? How? So you should have your name with a product, with a date. So that type of a document, and that document is cannot be created by you only. So any government or invoice. So those things should be there, and also that should maintain a date. So and what happened by having these raw things, raw evidences, if you go for a court, there is a high chances of other lawyer proving that it is not yours, it is created. There are, I think, high chances. So and also you have to prove before court that there is, some of the damage happened me, monetary loss happened me, and it might happen damages. You need to prove all those things.
Okay.
But once you got a registration, you need not to prove all these things. Just show that I have to prove ownership, you have a certification of a granted, then that's given by government. You can tell that I am a registered owner, everybody will accept, and you need not to prove a damage, because once why they give a right, that prove that you are only owner, you are only a owner. So that's why need not to prove damages, profit you claim direct profits claim directly. So there is much headache on the registrations. Otherwise you have to prove. There's a high chances of losing a case in a court. It's protecting, that's it. And also you can monetize it. Like if you're not registered, means you cannot sell, means there is a question of ownership. How can you sell?
Correct.
So, or how can you license, how can you franchise? Or as I said, if you want to sell in an e-commerce platform, they are asking for a registration, especially the trademark.
Okay.
And coming to the point of copyrights, so many of the work is prepared by team. Like you have actors, you have a musician, editor, so or with a painting or something, yeah, sole owners are there. But many of the things, there is for software coding, there are team which help for coding, all are the owners. So when you file for a copyright, you got a copyright registration for your name, means those all co-owners will become nullified.
Okay.
So that's the advantage. Otherwise they have also rights.
Correct.
So and also they have a rights to oppose in the time of objections period. But in a one there's only 1 month. So and they should aware about this. They were not aware about your filing is how they object, right? So there's a lot of advantage, like monetize. The investors, like I saw many investors, they will trust you, means investing by having a IP rights, because they believe like that. So you are serious about this, and it's a long run. So not like you're playing with this. They will think like that. So you'll get investments from that also. The perspective of investment. These are not mandatory thing, but the mindset of investors will look, if you have an IP or if you have a trademark, so that they will look in a different way. So that's the advantages of having and not having. So yeah, no law tells you that mandatory go for registration. If you don't have a registration, means we will seize your product. No law tells you that, but it gives advantage, smooth business process, all these things. It's a give advantage. For example, you saw many like Brahmin's Cafe. So Brahmin's Cafe, actually recently we discussing with one of my friend. So he told that we'll go for Brahmin's Cafe. So when we search in a Google, there are a lot of Brahmin's Cafe. He confused which Brahmin's, like that. Brahmin's Cafe is not a registered trademark. So that's why. So there are lots of similar things which arises. Means you are a follower of Brahmin's Cafe, so that's a unique taste or something have. So another Brahmin's Cafe is come to the similar locality or something, you'll get a confused. So the loyal customer also, he will go for that customer. It's a loss for you. So that's why have a unique name, get a IP registration as early as possible, and get all the advantages of IP rights. So rather than suffering in a later.
And if somebody would like to know more about the IP, so would you suggest any sources for them?
First thing is barracks. Barracks, like for a trademark act is there, copyright act is there, along with the rules, means the procedural rules. And for every act, every type of trademark, there is a trademark acts are there. Along with that, I always follow the Spice IP. It's a website, not an app. So in that website, the blogs and IP like magazines, like what are happening with the IP world, Indian, international, everything, like the news of IP will be published. I follow that one, Spice IP. So that's enough, I think. And also some of the law firms will post the blogs, so you can go through those things. But if you want to know means updates about IP, means follow the Spice IP. That's the best one.
Okay. And how important it is for someone, I mean, who is into the practicing IP or IP practitioner, to keep them updated every time?
Yeah, it should mandatory, because these IPs always go hand in hand with technologies. Technologies is also updating. So some of the some of the laws is not in a barracks, so which governs, but also we have to follow. So unofficially, like any judgments of the courts, we have to follow. Like unofficial things which trendy, we should follow. So that's why we should update in so every day. I should say every day. So you should go through what's happening, and also you should strategize your business or a profession through the trend. Like in nowadays, tech and fashion, so it's growing. So along with that, should you make for a design, you should go for a patent design, or outer design for a trademark. So these all changes every day, because in this profession there is no much experienced people. So like you never heard like I'm practicing IP from past 50 years, 40 years or something. It's evolving now. So that's why you should always keep updating yourself with IP laws, for especially practitioners, especially young practitioners. Yeah.
Okay. And if somebody would like to get into this field, so they might think about the money, right? So yeah, like how much someone can make in this field?
Actually, I'm a right person to talk about this, but if I tell those hacks or something, let's go publicly.
Okay.
So actually, you can make a lot of money. So based upon, like I don't mention exact money, but so whatever do in initial stages, you can charge. For example, I told about registrability report, just checking whether it's registrable or not.
Okay.
So we are charging for that, but we're charging small amount. But I'm telling them, for application you can charge, responding the objections you can charge, for appearing for a hearing you can charge, opposition you can charge, and renewal. So after 10 years you have to renew your trademark. For that you can charge, and licensing, contracting, and there's a thing called assignment and transmission. You are selling to someone, there is separate process for transforming your trademark assets. So the transmission of the things, because nowadays lots of IP, they're already registered. The selling company, through selling company, they are selling a mark also. For that assignment transformation you can charge. So, and for coming to the copyright application you can charge, copyright objections you can charge. So, and patents also, patent application they were charging a lot, patent renewals you can charge. So I'm just talking about the only, so so when lawyers will come into picture, there is a fight or an issue will come, the lawyers will come. Just all these I told this is before issue comes. So when issue comes, then court proceedings will charge. And in the court proceedings, you will arguing for a brand value, reputation. So that has some amount. Like it has a valuation of this company, like this brand has a valuation of this. So you are protecting, or if you are defending, you are claiming that valuation.
Okay.
So your valuation might be in lakhs, or sometimes it's crores. So if you protected them, means they will pay you a huge huge
Correct.
amount.
Correct.
So
Yeah.
that's why it has a lot of money. But yeah, strategies and application of mind, it's very important.
Yeah. If you have right knowledge, you can
Yeah,
earn money.
knowledge is basic thing.
Yeah. Yeah.
Raw knowledge, and how you tune in that knowledge into monetization. Yeah, that's very important.
Okay. And do you also think that so we need to create some awareness on the IP, because like many people are not aware of this subject, or they are not taking it serious. So do you think so if we bring some changes in the institutions and all to create the awareness, that would bring the changes in the later stage?
Yeah, sure, that's mandatory. That will help two people. One is a professional like us, means that increase our business and we'll get more clients. Another one is founders. Founders, why means they were not aware. So if they know about IP, means they can get advantage over that. I can also they can stops their legal issues behind IPs. So that's why the as I said, people are not aware of this IP. So even though it's rising, so I think they will get awareness. And yeah, even I'm also planning for how to aware these peoples. So so if I worked good on this, so I will do that also. So when I'm in college, we have that IP cell. So but we had that IP cell, but that's not working properly.
Okay.
So like calling 1, 2, 3 speakers for a webinar, think that's it. So I think in law colleges, mainly law colleges, they should start IP awareness to the students. And some of the colleges, it's even though mandatory, they will give compulsory to study other subject to parallel to IPRL, especially with the rural area colleges, other parts of Karnataka. In Bangalore, it's a every college will offer, and many people are studying. And also what I'm doing is I'm hiring interns.
Okay.
So what I do means I am hiring first, second, third year interns only. Why I do means if I give a IP knowledge in earlier stage, they can choose IP in a 10th semester. So then they can have a career with IP.
Correct.
So that's why I'm hiring only first, second, third year students, not looking for a fourth and fifth year students. So yeah, the people should get awareness about IP. So if anybody want to know about IP, you can contact me anytime. So I'll guide them A to Z.
If the institution is also interested to get in touch with you to conduct any session or something, so they can reach out
Sure.
to
They
you.
can also reach out me. So because I'm love and I want to do that one. So like helping or spreading the knowledge about IP. So because everybody should know in an earlier stage only. So because they do a creation innovation lot. They tell a people students to do a creation innovation, but they should also teach them to how to protect it. So otherwise, whatever you build, so you build like a huge. At the time of you're not aware about IP things, it will collapse in a day. Reputation will collapse. Everything will collapse. You have to rebrand. After rebranding, you will lose your customers. Consumer will get a confused. The best example is, so we'll take an example of Good Day biscuit.
Okay.
So you go for a shop and you will ask for a Good Day.
Right.
Good Day biscuit. So what if the wrapper or a name is changed and the same quality, quantity, taste of the biscuit is same? Do you believe that is a Good Day? No, right?
No.
So by looking the wrapper, by looking the name of Good Day, you'll purchase that biscuit.
Correct.
That's how the IP is in our mind. Means subconsciously it is there. Subconsciously it is there. So that's why IP is very important. So directly people were not aware, but indirectly they were following IP like these situations. Yeah.
Would you also come across any like a challenging situations when you are dealing with the IP cases?
Yeah, as a main challenge situation, the people are not aware this and a confusing laws. Like we have a international law, Indian law, so which tells that have a registration will protect you, and also for non-registration also protection is there. So there are confusing laws, and a big challenge is educating people. When I talk with the people, they are not leave it in their mindset. So that is a big challenge. And some of the non-IP professionals spreading a rumors of non-rumors. Recently, one of my client I was speaking the consultation, we were doing a consultation. She said that one of chartered accountant said it in earlier days it was a trendy, like a 10 years back IP was a trendy. So now this is not a trendy. So basically go for IP registration not because of trend.
That's
We
true.
want protection.
Correct.
Protection, that's why we are doing. So those type of rumors, and it's very costly. So people will tell it very costly. So actually, so compared to other countries, in India it's very cheap.
Okay.
Professional fee, government fee.
Okay.
So recently I was dealing with one of the Dubai client. So means I'm not doing, but I'm helping with that. So they will, in the Dubai government will charge for application, they will charge for publication, they will charge for registration, like a trademark. So in India we charge only for applications.
Okay.
That's it. So, and in India for a one class, it's for there's a two type of charges. One is for small business, individual, sole proprietor, MSME and startup. There's a one fee.
Okay.
One fee, and for other than these companies,
Okay.
like a private limited company, partnership company, trust, there is a one fee.
Okay.
So in a Dubai, its total of a registration process will cost around, only registration process, not opposition, objection, leave it. It will cost around 1,15,000 or something. In India, it will cost for 4,500 for type 1, what I said for startup, those things. For a large company, it's a 9,000 rupees. The government, that's it.
Okay.
So compared to other countries, it's very less. Yeah. So you have to compare with property registration. How much you are paying for a property registration based upon your valuation,
Right.
right? How much, like, it will cost around 1 lakh or something. Sometimes it's based upon these things. So, but it is lesser than your property registration.
Correct.
This is also one of the properties.
Right.
That is the main myth they were, in a public, that the cost. So yeah, of course you have to pay for government, because they will grant license you. They will protect you. Protect means the court, laws making, they will protect you. So means anything cannot do with free, right? And also have to pay for professionals, because they will help with you with their knowledge. So for us it's a minimal, so we don't charge high or something. So, and yeah, I don't disclose now, but it's very cost effective. So rather you have to compare with property registrations and other countries, it's very cheap.
Would you like to give any piece of advice to young minds who would like to pursue a career in this one,
Yeah.
or who would like to know more about IP?
Yeah, first thing is, guys, it's crazy, and it's booming sector. So you look at next 5 years, the IPs, like IP conflicts will arise, and lawyers will get if you know about knowledge, you'll get a lot of cases, because it's a booming, and there is a lot of issue will come. And most of the people, it's already rising, and it will rise huge in next few days, because all of the people are trying to creating, innovating things. When it comes to creation and innovations, we have a lot of jobs. And we will get a lot of clients. That's why don't worry about myths, and don't worry about what a word says. That do research on yourself, like how it's booming. So what are the reason? So also it has an international scope. Like some of the laws, we don't have an international scope, like criminal. It's based upon jurisdiction.
Yeah.
So you can do a master's in outside in the IP topic.
Okay.
And so there is laws are different from country to country. So even the IP laws is different from country to country. There are lots of similars. If you want to practice in some other countries by going to the European countries and American countries, so you can easily understand those IP laws, because it's similar. And also you can practice from here by being an Indian. You can practice through international registration. You can contact with international clients. It has an international scope also. So it has a multi-dimension sector. You can if you have a knowledge and application of that knowledge, skill, and problem solving personality with you.
Okay.
So IP is a sector for you.
Okay.
So it's booming sector.
Yeah.
Yeah.
Good to know. And any 3 tips for business owners or the startups?
So actually, I always tell that do registration in early stage, consult with your IP rights, protect your IP rights, because those are your assets. How you manage like other assets of your company, these also your assets. So maybe in a early point you may not know about those assets. By over a period of time, or building a brand for a couple of years, so it will give a huge rewards.
Okay.
So knowingly, unknowingly, it will give a huge rewards.
Okay.
Like you spent like a small amount for a registration in early stage. So and later, knowingly, unknowingly, you will spend a lot of money for advertising.
Correct.
So after building a brand, so it will give a huge response. Also, you can sell it, license it. You can make money out of these things. So the basic advice is go for registration early stage.
Okay.
So don't wait for establishment in meanwhile in a 1 year or 2 year anything can happen. You may lose your brand.
Yeah.
So anything can happen. So it's coming to the brand and coming to the point of copyrights. So you want to have a proper legal ownership with a proof, go for copyright registration. So I don't tell you that come to me for registration. So learn yourself by copyright registration. You can apply by yourself.
Okay.
So and take a registration also. Okay. Copyright, it will not a huge cost.
Okay.
So it is lesser cost. So depend upon what type of work it's they will charge amount that. So and patents. So so you have an idea. So don't go and pitch anywhere like any audience or an investor. So if you have a protection means it's better. So otherwise somebody have a chances to. So like in a patent application there are two type of application. One is complete application, means after you build a whole thing you can go for application. Another thing is you are in a building stage, you have a time of 12 months. So apply it, take a 12 months of time to build. So there is a option for that if you are in an early stage. So and government is bringing a lot of schemes for to bringing awareness about IPs. They were doing and also to learn, I forgot to mention, to learn WIPO, World Intellectual Property Right Organization, who is handling international registrations.
Okay.
So it is based out of Geneva, Switzerland. So what they do, they were to bring awareness about IP, they are conducting lots of courses.
Okay.
So paid and unpaid courses also.
Okay.
They are also publishing lots of information, but they are doing for international registrations.
Okay.
So you go for WIPO website. So you will get detailed for learning purpose.
Right.
Even I learned lot of international things from WIPO website only.
Okay.
So that's how can check. So yeah, for founders or early founders, businessmen, so protect as early as possible.
Sure.
So at the initial stage, when you create it, go for registration.
Okay.
So that you can change it. If
Right.
you are, there's nothing to working with means, you can change it.
Sure.
That's the advice I can give.
Sure.
Yeah.
And we are almost at the end of this episode. So I have just like one last question for you.
Okay, sure.
If you would not be doing IP or IP practitioner, like what else you would be doing?
Actually, I studied law in my school. Maybe I practice as a normal advocate in a courts, or I'm interested in politics. So maybe into like just touching upon those things. That's it. But IP has changed my thinking and my lifestyle.
Okay.
So that's why I'm here. So or as I said, I'm becoming a normal advocate practicing in courts.
Good.
Yeah.
Good to know. And thank you so much for taking out time for us.
Thank you so much for inviting me. Yeah.
It's my pleasure.
Yeah.
Thank you. Thanks a lot. And
Thank you.
we'll meet again.
Sure. So all the best for you also.
Thank you.
Yeah.
This is just a small token of gratitude.
Thank you so much. Yeah,
And I
thank
wish you all the best for your
Thank
future.
you so much. Yeah.
Fine, we'll meet again.
Sure. Yeah.
I had a nice discussion with Mr. Puneeth on intellectual property rights. Hope you enjoyed the show. Please like, share and subscribe. Thank you for watching us.